through the Orange Book procedure, they had also to identify whether they are willing to do it, because in a way we know that SAP patents might be not valid, and the standard organization, they are not doing that work to check the validity of the patent. So during that short time, he had to take a decision to identify whether he is indeed going that way and brings the defense. And this is a very short time in order to see whether the patent is sufficiently valid. First, there will be no decision, no court decision, and and I think that's the second main difference now to the new situation is the offer had to be unconditional, and unconditional under German situation was that it required a complete surrender. First, surrender that the patent is standard essential. We don't know, some of the patents which are somehow put under the standard, it must not necessarily standard essential. And the non-infringement argumentation had to be given up. And what is, of course, most critical is also the fact that the user had to surrender the validity attack. And of course, this makes it, to some extent, a bit unfair, but it was the reason, and I think the reason that we had here I think in Germany we had so many cases because it was also considered to be too patentee friendly. And I think I give the floor to Peter again after I'm going to explain our way how we are going to do it now in the future with the Huawei procedure.
Yeah, thank you, Alexander. But I think it's very important to realize what I'll just call the Orange Book background to this. That is really what triggered our competition commissioner to see a role for antitrust and to step in and, in his mind, to really curb what they thought of at the EU level of an excess at national level, where they thought IP protection just went too far. However, in so doing, and let me just re-emphasize what Alexander has already pointed out and what's on this slide, I think our regulator went extremely far because essentially they assumed if you have an SEP or a set of SEPs, you are dominant, full stop. It's important to hold that thought. And the second thought, which is important to hold, is that our regulator decided that for the licensee to be willing, all the licensee had to do was to show up to a meeting. It might have been nice if at that meeting maybe you would have exchanged a business card and given some smiles to the other side, but that is all you had to do. Sit there for 2 hours, smile politely, and leave, and you were essentially deemed willing. So really what those two assumptions did, rebuttable on paper, but not really in practice, it shifted the balance in a dramatic way to the side of the licensee. Now, what did our Supreme Court say? And I must say, they rarely come up with precedent-setting judgments, but I think this is one. And it's a very balanced one if you think about where we're coming from. What the court says is that an SEP holders seeking to enjoin implementation of an SEP may constitute an abuse of dominance. That's very different from where the Commission had headed, which was essentially an assumption that you were abusing dominance, which, good luck, you could try to rebut. Now, the rationale for our Supreme Court to step in, and they realize they're stepping in on what is really the prerogative of IP law, the monopoly contained in the patent. They're saying, well, these aren't just regular patents. The SEPs, and it's important to realize that they really call it the special circumstances of the case. Well, these SEPs, they come with the commitment by the SEP holder to license on friend terms. And that allows antitrust a certain intervention because commitment to friendness. We're not going to talk about friend, we're just going to talk about the commitment to license on friend terms. That creates legitimate expectations from third parties that the SEP holder would grant licenses on friend terms, such that refusing to do so, which was the case at hand and had been the case at hand, at least in the Motorola case, may be abusive. In so doing, I think we would probably agree, our court struck a relatively fair balance between, ensuring free competition on the one hand, I think what Henand called the prerogative of antitrust, yet on the other hand, safeguarding proprietors' rights of the SEP holders. Now, how does this system work? And that's where Alexander's going to take over again.
Yes, the decision has been rendered in July last year, and there are fortunately already two decisions from German courts, so-called post-Huawei decisions. And from these decisions, we can already take some lessons. I include also a few speeches of our Chief Judge Kühnen from the Appeal Court to Düsseldorf, who gave some guidelines how this Huawei procedure has to be implemented by the courts. All in all, my impression is that first the Huawei procedure given by the European Court of Justice gave some margin for the courts to apply, but it seems to be the inclination of the German courts to take that more patentee friendly again. So you have a procedure given by the European Court of Justice which gives a good margin in one or the other direction, but German courts, they are going to be, again, patentee friendly, but of course they have to take this as law, as their procedure, because this is more than only a decision of our federal Supreme Court. It is something what puts the system under a very constrained framework. And what is now the method, the procedure? So I think it's a quite simple way how to get this to a quick end. First, what is new here in the system? It is first up to the SAP owner to put upfront a notice to the other side to say, look, here's my SAP, and you are infringing it. And this requires, of course, according to the European Court of Justice, also a kind of substantiation of what the other side is doing. It's not only pointing to the SAP, it would require, and I think this is what the German courts already say, some substantiation. It needs to put the finger on particular products using that SAP. And then the other side needs to, in a way, to indicate a willingness of negotiation. This is something what we already know from the procedure of from the approach of the European Commission, but it stops not there. So for that willingness to negotiate, the German court give only a very short time frame, 4 weeks, last decided by the District Court Mannheim, and it makes also sense. I'll come to this later, why this could be so short, that notice. So he must make up his mind very quickly whether he is going to take a front license, and then it's no new, and this is of course in contrast to the Orange Book situation, it's up to the owner of the SAP patent to make the front offer. The front offer with a contract, with a license contract, with all terms which are usually in such a license agreement, and in addition, he needs to put a particular price for the patent into that front offer. And of course, there the European Court of Justice was right, because the SAP owner is that company or the entity which knows better what is front, and it is not the user of the SAP, because typically they hold already license agreements, and they can better compare what the value is of the SAP. So that's new. And then there will be a front offer by the SAP. It is then up to the let's say the defendant or the user of the patent to indicate, yes, I'm accepting this, or he is entitled, according to the European Court of Justice, to put up his own front offer. So this shows that there is not only one front offer. It shows that there might be a patentee-friendly front offer and one which is more in favor of the user of that SAP patent. And now, what happens if the two parties do not agree on one of the, or do not reach something in the middle? So the European Court of Justice put in a third point, which is also, I think, new for us, that if they don't come to an agreement, the parties, they have then to somehow to refer this to a third party. In the decision of the European Court of Justice, it is said may agree on it, but I think it is from the overall structure, it is pretty clear that they have to do something. They have to agree that this is put to the to a third party, and this third party is maybe a court, an arbitration court. It could also, according to our Chief Judge Kühnen, it could also be a normal German civil court if, what is his opinion, if it's only done in one instance, that discussion on the front terms. Yeah, that's the main aspect of this procedure, and of course that the user of the SAP patent must do something in addition if he's already using it. And this is the last point of the decision of the European Court of Justice, namely that he needs to render account for what he did in the past, and in addition he needs to provide a security for the use of the SAP patent until that decision of the third party is then somehow decided on the front terms. And I think it's not yet completely settled, all this, and we do not yet exactly know how this is somehow implemented in practice, because there are only two decisions. But one thing is clear, and this makes it also different to the Orange Book decision. The owner, let's say the user of the SAP patent, he can continue his validity case at the Federal Patent Court, or he can continue his revocation claim at the opposition, in an opposition proceeding. And I think this makes it pretty convenient, more comfortable for the user, because he is not under pressure to simply surrender everything and to simply say, okay, I signed the agreement, even though I know that it might be not a valid patent, which is enclosed in the portfolio, which is the SAP. So I think in total it puts the pendulum back to something where I hope that there are still inventors out there that they say, okay, this is still sufficient in order to bring my patent under a standard.
Okay, so very briefly to wrap up, I think we have a framework in Europe now, how to deal with injunctions. I think very importantly, as Alexander has, let me try this one. I think very importantly, as Alexander has pointed out, this framework should not stop companies continuing to, or maybe it should, given how our system is reacting to me, should continue to work under standards, because after all, standards are good for consumers and I think also for the producers. But what does this framework not do? And so I think to stay to our morning opening of turbulence and fog, I think the fog has burned off some, but not entirely. Most importantly, our Supreme Court has not ruled on dominance. It wasn't asked to do so, so it didn't, it can't. But that means there is no assumption of dominance necessarily attached to the SEP. And the absence of such assumption, which the Commission would love to have to enforce antitrust very aggressively, the absence of that explains why in the US, where Apple very much wanted to drag Samsung to task on antitrust grounds as well, the DOJ effectively just smiled and waved, because it said to prove dominance would be such a difficult task in a fast-moving market, as is, the smartphones and other high-tech markets. It's very, very difficult. One. Two, and I should maybe move on to the appropriate slide here. Two, there is no ruling whatsoever on what is or is not FRAND. Fortunately, I think our antitrust regulators have been very firm that that is nothing they have a right to rule on. And it is really to the parties and the national judges to, well, deal with what's probably the hardest task of it all, namely how much to pay for what. That doesn't mean that antitrust was just a guest appearance, and I wouldn't love to come back to next year's event, because there are clearly questions there, like royalty stacking. I think royalty stacking, as we see our big IP holders like Ericsson, like Nokia, moving away from being producing entities to really being IP holders, transferring their rights into a variety of entities like, for example, Unwired Planet, which is in litigation in London right now. I think, the royalty stacking, and also what should be the appropriate basis for royalty, the smallest sellable unit, the device, all these are things where our regulator has already flagged they might be very interested to look at. Dominance cases of sort of the bread and butter type, excessive pricing, predation, will continue as under our old precedents like IMS and so forth, McGill, continue to play a role. In fact, that is what the Commission is currently looking at in Qualcomm. And last, and then I'll stop, the transfer of rights, which of course is incredibly important as we're moving to a world where Europe has more non-practicing entities. The Commission's position, and I would recommend you to read the Samsung commitments, because not only do they fill in some of the framework that Alexander has put up, they also are very clear. The Commission believes the rights attached to the SEPs, and that includes this whole antitrust arena, will be transferred along with the SEPs. And I think that does mean that although really it's an IP lawyer's world, us antitrust lawyers still have a good reason to attend conferences like this and work hand in hand with our colleagues on the IP side.
I think this is the right finishing. I would be glad to have that discussion next year again, because of course we have already our thoughts stuck in what is FRAND and how to measure and how to come to a FRAND royalty. And what is if the SAP owner asserts only one patent, and after he says you have to take a license on the whole portfolio. This is a real issue. We have already some case law on it, but it would be really for a further session to discuss all these points.
Well, thank you very much.